the offer is to dismiss those.
You don't have to. I'll defend myself against them. Please call the other cops in.
No, I'm not.
I'll take on all of them.
No.
Make sure he's there.
Mr. Hicks.
I see him in the neighborhood anyway.
Your Honor.
Mr. Hicks.
So you can't punish me for any of this.
Himmer, Hicks. Names for the record, attorney first.
Hey, police court, Harry Baughman on behalf of the defendant. Sir, would you state your name for the record?
Albert Heimer Hicks Jr.
Thank you. Good morning.
The defendant
Your Honor.
That he does not wish to be represented by counsel this morning. I will remain in a potential advisory capacity just in case.
Okay. Is that correct, Mr. Hicks?
Yes, that's correct.
Okay. You know that, so let me see what's happening here. I see an offer that ends up dismissing a lot of matters. I can't be your lawyer, so I'll just tell you what's here. And Corporal Spidell is here. See what I'm just trying to make sure I understand the offer. So you have 8 open matters, and there is a recommendation to dismiss 6 of those matters in return for a plea on 2 of the matters, and both matters are being reduced to driving with improper plates. I think, it was driving unregistered motor vehicle reduced to driving with improper plates. Oh, I'm sorry. And the other one is being reduced to, I don't get this other one, Mr. Jansen. Is it being reduced to failure to report accident under MCL 257.621?
Welcome back to the courtroom, everyone, and buckle up, because what you're about to see might just redefine the phrase, talking yourself into trouble. Today's case follows Albert Heimer Hicks Jr., a self-proclaimed sovereign citizen who walks into court thinking he's uncovered some hidden legal truth that makes him immune to traffic laws. What he doesn't realize is that the court was literally offering to dismiss 6 of his 8 cases. All he had to do was stay quiet, nod, and accept the deal. Instead, he turns what could have been a simple $200 resolution into a courtroom crash course on how not to represent yourself. Watch closely. This one's a wild mix of confidence, confusion, and constitutional chaos.
Would you like to avail yourself of that offer? That takes something that was a $500 fine as the maximum to a $100 fine as a maximum with no points.
I never had a license. I never acquired a license. I have no contract with any company.
This has nothing to do with a license. So those license matters. The offer is to dismiss those. You want to go through all of these tickets then?
Let's run.
Okay. So let me just say, Mr. Hicks, if you're making a motion for, I'm not sure what you're doing. You sure you don't want to have, let me just ask.
I'm making a motion for a mistrial for the simple fact the officer did not have cause of action on private property. As far as the license is concerned, I'm going to rely on the decision from the Supreme Court and constitutional defenses.
Well, can you tell what those are so that the prosecutor can
of course.
Can say
I travel with the common law. I have the right to travel. Shapiro versus Thompson states that. Murdoch versus Pennsylvania states no state shall convert a secured liberty into a privilege. Y'all are calling driving a privilege or traveling a privilege. It is not a privilege. It is a liberty. Shuttlesworth versus Birmingham says I can ignore the license and engage with the right with impunity.
Here's where things get interesting. The judge lays out an incredibly generous offer. 8 charges reduced to just 2 minor offenses, each capped at $100, with no points on his record. Most defendants would jump at this deal. It's basically the court saying, let's just move on. But instead of recognizing a golden opportunity, Hicks doubles down on a belief that's as misguided as it is popular among sovereign citizens. The idea that a driver's license is a contract and that traveling is a right the government can't regulate. What he doesn't grasp is that the law doesn't bend to personal interpretation. This is the calm before the storm.
In front of me.
Well, I'm trying to do my due diligence, Mr. Hicks. driving while license suspended, driving an unregistered motor vehicle, driving without insurance. Those are the 3 counts. Also pending is the driving while license expired. Count 1 is failure to display a valid operator's license, not on purpose, person. Count 2, driving unregistered or untitled motor vehicle. Count 3, driving with improper plates. And then the last one I have, the charge is providing false or fraudulent insurance information.
That will have to be proven.
Okay. Those are what, they're scheduled for a bench trial before the court right now. And what I was trying to explain to you is that there's an offer that's been made by the prosecutor.
I understand.
Hold on 1 second. I'm already dismissing 4 of the matters because the officer has not appeared. Okay. So the prosecution couldn't go forward. So those are being dismissed without prejudice. And those would be counts 1, 2, and 3 of SP 1335615. I assume Officer Reed is not present. And that was scheduled for trial. I'm dismissing those, okay? The driver's license expired, case number SP 1218560. I'm dismissing that count 1 that's up, as the officer Hernandez has not appeared, okay?
I wonder why.
Don't worry, a lot of people, that happens sometimes. Well, let me just say, let me just say, they may have been here before. I don't know, because some of these you haven't appeared for. So I don't know if the offer would change. So the only matters that are pending now, the other matters are gone, that were scheduled for today, would be the fraudulent false insurance information, SP 1055542.
And there it is, the moment that changes everything. Hicks reject the offer outright, declaring he'll defend himself. It's a decision that screams overconfidence and misunderstanding. The irony? The court wasn't trying to trap him. They were giving him a lifeline. But sovereign citizens often believe that by invoking old case law or misquoting constitutional language, they can outsmart the system. The reality is, courts deal with these arguments constantly. They've heard every version, from no contract with the state to I'm a free traveler. Every time, the result is the same: frustration, fines, and...
What the prosecutor does a lot of times is that in an attempt to resolve a matter, they'll have you plead, but they'll ask the court to accept the plea to a lesser offense that doesn't...
I understand that doesn't hold as much weight as...
that doesn't affect you as
I understand it, but I do everything constitutionally. I don't follow laws or codes. I follow
well then that's what this is about. These are laws or codes.
Those are not laws. Those are codes.
Okay, so if you...
They are not laws.
Well,
the Constitution, that holds no weight with the Constitution nor the Supreme Court.
Okay.
And I'm willing to take it all the way to
Your
the Supreme
Honor,
Mr. Hicks, just hold on, please. I'm just trying to get...
Because it seems like you're trying to talk me into something.
I'm not trying to...
Mr.
Hicks.
I have nothing to do with them. Never had a contract with them.
Okay, Mr. Hicks. I'm not trying to talk you into anything. I just want you not to come back and say that I didn't explain something to you. And I am not your lawyer. I'm the judge. So I just want to make sure, though, that you don't come back with something else. And I just wanted to let you know, because you didn't talk to the attorney, what was being offered. That's all. And you've made your argument. I'm going to have the prosecutor make an argument, but I've already gotten rid of some of these, okay, for other reasons. And so I just want you to know that at least with respect to the offer that was made before, and it may have changed, these other 3 matters would be dismissed, I think. Yes, these other 3 matters would be dismissed. The failure to display, the driving unregistered, and driving with improper plate. But that's only if you plead
I will not plea. I refuse.
Okay, all right. No problem then, Mr. Hicks. I'm just telling you what that offer is from the prosecutor.
I
It has
understand.
nothing.
I
So,
understand. I'm 57 years old. I speak English well, and I translate.
Here's the breakdown. Hicks starts quoting cases like Shapiro versus Thompson and Murdoch versus Pennsylvania, claiming they prove his right to travel freely. What he doesn't realize is those cases have nothing to do with driving a motor vehicle. They're about freedom of movement and taxation, not traffic law. But in the sovereign citizen playbook, facts rarely get in the way of a good-sounding argument. What's tragic here is that Hicks could have walked away with 6 dismissed tickets. Instead, his defiance just locked him into a courtroom showdown that didn't need a...
Your Honor, I guess I would like to speak with Corporal Spidell about these cases, but prior to that, I just wanted to clarify that the defendant has submitted to jurisdiction.
thank you.
Thank you. I have had the chance to speak with Corporal Spidell, who was the ticketing officer on this case.
Okay.
We are requesting an in-person trial date.
Beautiful.
So just for the record, all we have left are the 4 misdemeanors that I indicated.
Yes, Your Honor.
Okay, all right. But I need you to be ready to respond to Mr. Hicks's motion. He just made an oral motion. I don't know if you want to do that now or do that at the time.
I can do that at the time. If you could actually reiterate his motion in writing, that would be
Can you
helpful.
put that motion in writing, Mr. Hicks? And you would have to give it to the prosecutor, Attorney Jansen.
Well, the thing is, when I was reciting it, no one was taking record of it.
We
So
have
that-
record. We have a record of it, Mr. Hicks.
So
I mean, we have a record of everything. No. Let me tell you, Mr. Hicks, a lot of times written motions are required. And usually, if that happens, then written responses are required.
okay, beautiful.
I'm just trying to,
Where would I bring or send these motions?
you can file it with the court and with a copy to Attorney Jansen.
You will have to send me that information because I have nothing to jot.
But the filing with the court is different. You should already know how to, there's nothing special about that. Okay? And give me 1 second. I'm going to try to get a date. So that means you would come down to court.
Well, I wanted to do it in the first place.
Okay.
For,
All right. It's still scheduled for a bench trial.
Beautiful. For a bench trial.
So I can schedule this for the adjourn this bench trial until March 27
Hold on.
in person,
Mm-hmm.
9 a.m. It is right now it's scheduled for a bench trial. And so that's what we would have been going forward, but we'll move it then in person. So make sure that you come in. If you have any witnesses or other evidence, make sure they're present. And if
At this point, Judge Milhouse shows remarkable patience. She's calm, composed, and still trying to help Hicks understand the offer, even though he's completely misinterpreting her intentions. Many judges would have cut this off much sooner, but she keeps giving him opportunities to reconsider. This is where you can really see the professionalism of the bench. She's walking a fine line, respecting his right to self-representation while ensuring he doesn't unknowingly harm himself legally. But make no mistake, her patience has limits, and Hicks is quickly testing them.
around, because that's not anything that's allowable.
Oh, it's not?
No, it's not.
Law.
It's not allowable. It's not allowable because the court has to do its business for everybody. Okay.
Even when I win this, I'm not allowed my cost and fees?
We're not going to talk about that. You were talking about sitting around and waiting. So you're not.
I mean,
you're not.
like a game to try to pressure me out. But
Mr. Hicks. So Mr. Hicks, just like I'm not imposing any costs and fees on you when you missed your court dates. You missed court dates earlier. And there's, I mean, You've been doing that. I see it.
I walked in the same day down at 36th District and
So,
rescheduled.
Mr. Hicks, I already made my decision now. Come on. I made my decision. You asked me, and I said I wouldn't be able to
don't try the intimidation thing.
Mr. Hicks, I'm gonna talk to you. Mr. Hicks, you
Yes.
can listen to me for a second. You can only be intimidated. No, yeah, you can only be intimidated if you feel insecure. So if you feel insecure, that's where that comes
it's
from.
not feeling
So
insecure.
nobody's trying to do that. Mr. Hicks, I just say,
We'll see. We'll see.
but Mr. Hicks, can I just say that you've been given I don't even want to say, because we've been following the law, you've had cases dismissed because that's what we're doing. Because of it. Not in spite of it. Okay. So I hope it's fine that that's happened. So we're down to 4 matters, and it sounds like you have no problem with coming in. Correct?
I still would like a jury trial. I would love a jury trial.
You're wanting a jury trial?
Yes, that's what I asked for in the first place.
You asked for a jury trial at some point and didn't appear. And so it went into show cause status.
Now we're entering the alternate reality phase of the sovereign citizen argument. Hicks claims he doesn't follow laws or codes, only the Constitution. As of that, grant him a personal exemption from traffic regulations. But the legal system doesn't work that way. The Constitution sets broad principles, while states define specific laws, like traffic codes. Under its framework, refusing to recognize them doesn't make them disappear. It's like saying you don't believe in gravity. You'll still hit the ground. At this point, the courtroom tensions shift from legal debate to quiet disbelief.
It says I would like a jury trial.
Okay, Mr. Hicks, I scheduled a jury trial for you. It looks like a couple of times, and you did not appear. So
yes, I did.
Okay, but let me just say, we were ready. Okay, Mr. Hicks, you want to get some counsel for that? Because it really takes a lot. I can't be your lawyer. We have to choose a jury. There's a lot of things that happen. And if you don't believe in the law to begin with, let me do this. I don't
color law. I believe in the Constitution, the supreme law.
Mr. Hicks, you can put your motion in writing. Ms. Jansen, you respond to it, and we'll schedule that for a hearing date. Then you don't have to come in. And then we'll see if this moves forward. If this is moving forward for a jury trial, I have to give you a jury trial date. That's completely different from a bench trial date. Okay? Like our scheduling is different.
I'm getting the fees out of this.
Well, why don't we do that? We'll use the March 27th date as the hearing date on Mr. Hicks's motion. That I think your motion is, so you were saying something about not being subject to
no cause of action on private property.
Okay, so why don't you put that in writing?
And I will.
Put that in writing, and Ms. Jansen will. So that needs to be filed by. I'll just indicate.
And just for the record, is suspicion a misdemeanor or a felony?
Oh, you don't have any felonies.
No, I said it's suspicion.
By now, Hicks is fully committed to his stance. He refuses to plea, insists he translates real well, and believes he's exposing some grand government deception. Meanwhile, the judge's professionalism shines again. She calmly accepts his refusal and moves forward, no argument needed. This is where experience shows. Judges have seen this pattern 100 times. Defiance followed by confusion when the consequences arrive. And while Hicks might believe he's standing for liberty, what he's actually demonstrating is how misunderstanding the law can turn a small issue into a personal...
No, you don't have to.
Yeah, go into the facts. Come
no,
on.
No, because I might have to hear. No, we can't do that.
With the Constitution. I'm waiting on him. Make sure he's there.
Mr. Hicks.
I see him in the neighborhood anyway.
Your Honor.
Mr. Hicks. Mr. Hicks,
I have nothing else to say. Y'all
Mr.
using.
I'm going to request a bailiff. Your
Yeah,
Honor.
request one, please.
Mr. Hicks.
If she's scared, tell her to call the police.
You don't need one now. He's at home.
They do not want to go by the Constitution.
Mr. Hicks.
I'm filming this too.
Mr. Hicks, you're not supposed to film it.
Oh, yes, I can.
No,
I'll do anything I want to in my house. You have no thing underneath my private.
all right. I don't know what to tell you. We'll see you on March 27th. You can file the motion.
I will.
Make sure the motion is filed by,
I got 14 days or so.
I'm just going to give you a little bit more.
Judge Milhouse, I have no problem with you.
I mean, no, but Mr. Hicks, I don't need you to become angry.
But
That's the thing. That's the thing.
That nobody wants to follow the law.
But Mr. Hicks, people can disagree about what the law
No,
is.
it's not about disagreement. It's right or wrong.
Well, Mr. Hicks,
And then that's wrong.
Mr. Hicks,
It's not about disagreement.
Mr. Hicks,
The Constitution was written so it wouldn't be no disagreements.
Mr. Hicks. Oh, there's always argument about the Constitution. Always. Just so that you know. Just so that you know. Just so that you know. Yeah, you wouldn't need me if there wasn't. So I just want you to understand that. And what we have to be here is civil, okay? We really have to be civil with this. We really need to be civil with each other. And I appreciate, but there's no tactics here.
Yeah, it is.
So, well, I'm not trying to do a tactic. So let me just give you a date and you can send it and be careful.
I'll bring it personally.
I just so for the record, because I have to say it for the record, I have scheduled some jury trial dates for you in the past. And maybe, I don't know if it's on any of the matters, probably on some of the matters that I'm
It's not in my paperwork.
Just today. Just for today. I'm saying.
But it's not inside of none of my paperwork.
Okay. Well,
And there it is, a textbook example of how courtroom patience meets constitutional chaos. The court gave Hicks every chance to resolve things easily, but pride and misinformation took the wheel instead. What began as a near dismissal turned into multiple trials, wasted time, and mounting frustration. Sovereign citizen arguments might sound bold online, but they crumble fast in front of a judge. If you found this case as shocking or entertaining, as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.